When are non-citizens considered deportable? There are a lot of circumstances which would render a non-citizen deportable. These reasons include both civil and criminal offenses. At times, it will be within the prosecutor's discretion to determine whether to commence removal proceedings after a deportable offense has occurred. Note that the determination of whether a conviction is a deportable offense requires an in-depth analysis of state and federal law. Non-citizens facing criminal charges should seek assistance from an attorney prior to assuming that they have or have not committed an offense with immigration consequences. An alien may be considered deportable after having committed certain criminal offenses. The following are some of the crime classifications that can lead to an alien's deportation: general crimes, controlled substances, certain firearms offenses, crimes of domestic violence, stalking or violation of a protective order, crimes against children, and drug trafficking. Crimes of moral turpitude are included within the category of general crimes. Moral turpitude itself is difficult to define. Generally, the concept refers to conduct that is considered to be contrary to the community standards of justice, honesty, or good morals. An alien is deportable if he or she is convicted of a crime of moral turpitude within 5 years, or 10 years in some rare circumstances, after the date of his or her U.S. admission, and he or she is convicted of a crime that leads to a sentencing of 1 year or more. An alien is also deemed deportable if, at any time after his admission, he or she is convicted of 2 or more crimes involving moral turpitude. However, the convictions may not stem from a single event of criminal activity. An alien is also deportable if convicted of an aggravated felony at any point of his or her admission. Also, he or she is deportable for failing to register as a sex offender when required. An alien is deportable after having been convicted of violating any state, federal, or foreign country law involving a controlled substance. However, the alien is generally not deportable for possession of no more than 30 grams of marijuana. Regarding weapons, an alien is deportable if he or she is convicted of buying, selling, offering for sale, exchanging, using, owning, possessing, or carrying, or attempting or conspiracy to do any of these acts. There are various offenses some aliens commit within the area of registering and falsifying documents. An alien must keep timely records regarding address and address changes. Failure to register. An alien is deportable for failing to register with the government in accordance with proper procedure. It is unlawful for an alien to tamper or misuse any immigration-related documents, such as visas and permits. An alien is generally deportable if he or she falsely represents him or herself as a citizen of the United States for any purpose. Note that immigration law is full of gray areas where it may be unclear as to whether or not an alien is in fact deportable. Immigrants should always consult with attorneys to determine whether or not their past behaviors could be classified as legal.